Don't put your kids on the deed. In the next 3 minutes, I'm going to tell you why you don't want to give your house to your children during your lifetime and what you need to do instead to avoid capital gains taxes and probate. Comment or send me a message and I'll give you a free guide to estate planning. No email address required. For those of you that don't know me, my name is Gary DeWitt. I'm the founder and owner of DeWitt Law Firm. I've helped thousands of individuals and families create effective and comprehensive estate plans. Plans that eliminate probate and tragic lifetime legal problems. Problems that could cost you everything you have, even if it's not your fault. Over the next 3 minutes, I'm going to tell you why you don't want to put your kid's name on the deed during your lifetime and what to do instead to avoid taxes and probate. Now, what I mean by during your lifetime is creating a lifetime deed. That's a quitclaim or a warranty deed. In just another minute, I'll explain another type of deed that is much better and doesn't change ownership during your lifetime. If you don't want to load your children up on capital gains tax, then don't give them the house with a lifetime deed. There are also other issues you need to consider. If you need 5 years Medicaid within 5 years of giving them the house, that is making a gift, then Medicaid will probably deny the application because you made a gift of your home. The denial will be in the form of what's called a penalty period. This period will last months to years, during which you or your children will have to pay out of pocket for the long-term care costs. The second reason is taxes. If you don't want to load your children up on capital gains tax, then don't give them the house with a quitclaim or a warranty deed. There are also other issues that you may not have considered. When you give your house to your children, capital gains tax is calculated on what you paid for the house, not what it was worth the day of the gift. So if you buy a house for $100,000, you give it to your children, and it's worth $300,000 and they sell it, they will end up paying capital gains tax on $200,000. If their base income tax rate is 15%, they're going to pay $30,000 of capital gains tax. If you used a trust or a beneficiary deed instead, they would pay little to no capital gains tax. It would be based on what it was worth the day you passed away, not the day you made a gift. Third, your children can have you legally evicted if you put them on the deed as full owners. Fourth, their financial problems become your financial problems. Every other driver on the street is now a possible lawsuit that your house can be used for. Your children's credit issues, medical bills, lawsuits, and more become your problems. The house becomes an asset that can be used to pay for their issues. Fifth and finally, it is difficult to impossible to change these kind of deeds. If you change your mind later, then the child or children will have to sign the new deed. I have seen it more than once where the children refuse. The solution to this problem is straightforward. I can write a type of deed known as a beneficiary deed in Arkansas. This deed lets you give the house to who you want when you pass away and keep lifetime control. Your children will save on taxes and their problems will not become your financial problems. You don't run into as many Medicaid issues and you can change this deed anytime you want to. Comment or send me a message and I'll give you a free guide to estate planning. I don't want to ask for an email or opt-in of any sort.